morning, everyone. May I have the appearances, please?
Good morning, Your Honors. My name is Bruce McFarlane. I'm a barrister from Canada and from Scottsdale, and I have been appointed as the amicus curiae prosecutor in these proceedings.
Thank you, Mr. McFarlane. For the accused, Mr. Šešelj.
Dr. Vojislav Šešelj, university professor and the biggest enemy of the Hague Tribunal. And I have to tell you one more thing. On Friday, the 28th of October, the registrar of the tribunal prohibited me from having all privileged telephone conversations with my legal assistants and advisors. Even when I had to serve sentences in jails in Tito's communist regime, no one dared to prohibit me from having privileged communication with my lawyers from the moment when the indictment was issued until the moment when the judgment became final. So, until my right is reinstated to have private telephone conversation with my legal advisors, I refuse to state my opinion about anything. I'm not even going to state my opinion about nice weather.
First, I take it by your submission that you are following the proceedings in the language you understand, Mr. Šešelj. And second, I believe there's a proper and appropriate forum and manner in which you can address those problems. Today, this trial chamber, consisting of myself, Judge Burton Hall, and Judge Howard Morrison, is delivering its judgment on the allegation of contempt against the accused, Mr. Vojislav Šešelj, pursuant to Rule 77A2 of the Rules of Procedure and Evidence of the Tribunal. This is only a summary which does not form part of the judgment delivered by the trial chamber. The only authoritative account of the trial chamber's finding is the written judgment, copies of which will be made available after the hearing. The amicus curiae and the accused will be given a confidential version of the judgment, and a public redacted version will be available to the public. On 3rd of February 2010, the Chamber issued an order in lieu of indictment charging the accused with having disclosed information which may identify 11 protected witnesses in violation of orders of a chamber in a book authored by him. The accused did not enter a plea at either the initial appearance conducted by Judge Hall on 29th of April 2010 or at the further initial appearance on 6th of May 2010, and thus a plea of not guilty was entered on his behalf on the same day pursuant to Rule 62A4. The trial began on 22nd of February 2011. The amicus prosecutor did not call any witnesses, but tendered into evidence 73 exhibits. At the close of the amicus prosecutor's case, the chamber granted the accused request to postpone the start of his case to enable him to prepare his defense. Between 6th and 8th of June 2011, the accused called 5 witnesses and tendered 4 documents into evidence. Rule 77A provides that the tribunal, in the exercise of its inherent power, may hold in contempt those who knowingly and willfully interfere with its administration of justice. In the present case, the accused is charged with contempt of the tribunal pursuant to Rule 77A2 for having disclosed information relating to tribunal's proceedings, in knowing violation of an order of a chamber. Disclosure of information within the meaning of this rule includes the publication of a witness's identity where protective measures have been granted to avoid such disclosure. The mens rea element for this form of commission of contempt is the knowledge of the alleged contemptor that his disclosure of a particular piece of information is done in violation of an order of a chamber. The chamber shall now turn to its findings and will start with the material elements of the offense. First, the accused has acknowledged that he is the author of the book. Second, in light of the evidence presented, the chamber is satisfied that at the time of the book was published, 10 of the 11 witnesses were the subject of protective measure decisions or orders issued by the Session Trial Chamber. Third, the chamber is also satisfied that the book contains the identifying information of each of the 10 protected witnesses and suggests that they could be involved in the Session case. The chamber is thus satisfied beyond a reasonable doubt that the book violates protective measure decisions or orders issued by the Session Trial Chamber. The chamber shall now turn to the mental element of the offense, namely whether the accused knew that the information contained in the book was subject to protective orders or decisions issued by the Session Trial Chamber at the time of its publication. The chamber first considers that the decisions on protective measures of 1st of June 2005, 30th of August 2007, 10th of September of 2007, and 23rd of October 2007 were all inter partes documents which were provided to the accused. He was thus fully informed of the protective measures granted by the Session Trial Chamber by the time the book was published. The chamber also notes that on a number of occasions throughout the Session case, the accused requested that protective measures previously granted to the witness in that case be altered by requesting their reconsideration or leave to appeal them. It is thus clear to the chamber that the accused was aware that protective measures must be varied by the chamber which orders them, and that he could not simply reveal the identity of witnesses who had been granted protective measures as he saw fit. Referring to 2 orders issued in the Session case, the accused submits that the Session Trial Chamber decided that each witness can eventually decide for himself whether to testify with protective measures. The chamber recalls that these orders pertain to one particular witness and no other. Had the Session Trial Chamber wished to leave the protective measures in place for other witnesses, it would have done so. It did not, and thus the chamber considers the accused's contention to be irrelevant to his responsibility pursuant to Rule 77A2, where the only relevant consideration is whether he knew that his disclosure of a particular piece of information was done in violation of an order of a chamber. The chamber is thus satisfied beyond a reasonable doubt that the accused knew he was disclosing information which identified 10 of the witnesses and revealed that they could be involved in the Session case when he published the book, and that he did so intentionally with the knowledge that by doing so he was violating decisions of the Session Trial Chamber. Accordingly, the Chamber is satisfied beyond a reasonable doubt that the accused is guilty of the offense of contempt pursuant to Rule 77A2 of the Rules. In its determination of the sentence, the Chamber took into consideration the gravity of the offense as well as the need for deterrence. In particular, the Chamber notes with grave concern the deliberate way in which the protective measures decisions imposed by the Session Trial Chamber were violated and considers this a serious interference with the administration of justice. The Chamber has also considered the expanded scope of disclosure given the book's electronic form and availability, as well as the recused lack of remorse. The Chamber has also given particular consideration given to the potential adverse impact that the accused conduct may have upon witnesses' confidence in the tribunal's ability to guarantee the effectiveness of protective measures. Furthermore, the Chamber recognizes the need to discourage this type of behavior and to take such steps as it can to ensure that there is no repetition of such conduct on the part of the accused or any other person. For the foregoing reasons, having considered all the evidence and arguments presented by the parties, pursuant to Rule 54 and 77 of the Rules, the Chamber finds the accused, Vojislav Šešelj, guilty of one count of contempt of the tribunal, punishable under Rule 77A2 of the Rules, and sentences the accused to a single term of imprisonment of 18 months to be served concurrently with the sentence of the 15 months imposed by the Chamber on 24th of July 2009 in case number IT 0367 R77.2. Hearing is now adjourned.
All rise, veuillez vous lever.